Good morning and good afternoon. My name is Joe Edmonds. I'm the Director of Practice Development for JAMS in the Midwestern United States. JAMS is the world's largest private provider of alternative dispute resolution services. We're so glad to have so many of you joining us today from all over the world. I'll ask Judge Epstein to start introductions in a moment. A few housekeeping items before we begin. Today's session offers 1 hour of continuing legal education credit for Illinois attorneys. We are required to track attendance for these credits, and we'll be using a webinar polling feature for that purpose. We'll alert you to an upcoming poll by voice. It will then fill your screen so you can't miss it. Please use the poll to indicate whether you want CLE credit or not. They Tell Me certificates will be delivered by email in approximately 2 weeks, but usually it takes less time. If you requested CLE credit but opted out of email communication, your certificate may be delayed. If you have questions about the program or about JAMS, I'm happy to chat anytime or to put you in touch with our panelists. You also have links to their biographies and contact information in the materials for today's program. Thank you for coming. Judge Epstein, the floor is yours.
Well, thank you, Joe. For all of you who have joined us today, thank you for attending and welcome to the ever-shifting landscape of BIPA. BIPA was Illinois' statute that was enacted in 2008. And while it may be the first state in the United States to enact legislation to protect biometric data, it is by no means the last. And in this first position, we find ourselves dealing with a lot of questions that haven't been answered elsewhere. And we'll be talking about all of those. I'm joined here today by my friends and colleagues, Judge Anna Demakopoulos and Judge James Snyder. We all are neutrals at JAMS, where we do arbitrations and mediations. They will introduce themselves in some detail later on, but for purposes of giving you a little bit of background on me, I was a trial lawyer for many years, a fellow with the American College of Trial Lawyers. I then served on the Circuit Court of Cook County, including in the Chancery Division, which is the division that handles all the class action cases in Cook County. And then I served a period of time on the Illinois Appellate Court, where we reviewed a lot of these types of cases. Since 2015, I've been a neutral at JAMS, and over the years, I've mediated several dozen, actually more than several dozen BIPA cases, including some of the ones that get a lot of publicity and citations in the future. So first of all, I want to point out a couple of things which are pretty obvious, but should be forefront in your mind, which is mediations are all about risk. It's where hopefully the parties identify all the risks, assess those risks, and make a sound business decision in full understanding of the risks about whether to try to settle this case or whether to go down what is the other binary choice, which is to go through the litigation process. And in any mediation, emotion often clouds risk assessment, often for the clients, sometimes for the lawyers too. As a trial lawyer, I can tell you, we often get very attached to our clients and our clients' positions on these cases. We believe in the cases, we believe in our clients, and emotion can enter into a lawyer's assessment also. So that is understandable. I find in these BIPA cases that the emotion is usually most present from the decision makers on the defense side. And that is completely understandable. Often the actions that led to them and their company being sued in the class action was something that didn't have a negative intent. It was often trying to make their operations more efficient, more cost-effective, more accessible for their customers and for their employees, and yet they find themselves in a lawsuit looking at potentially catastrophic potential outcomes. That emotion makes it all the more difficult to try to guide focus in a mediation and to have a more clinical assessment of risk. And as we have seen in Illinois, there are few, if any, civil causes of action now with more risk than BIPA. Even with the recent decisions of the Illinois Supreme Court, there are so many unanswered questions that people in a settlement conference, in a mediation, have to be aware of as they decide that choice of whether to settle or whether to go through litigation. One thing that we see all the time in the pre-mediation submissions that are given to us before we do a mediation by the lawyers for each side are citations to decisions that come from the circuit court level, from the Illinois appellate court level, from the federal district court level, and maybe even from the Seventh Circuit on appeals having to do with a federal district court decision. The one immutable truth is that none of those decisions mean anything until we have heard from the Illinois Supreme Court on that subject. This is an Illinois statute, and the Illinois Supreme Court has the final say in all of those things. It's clear that however well-grounded the decisions of lower courts are or federal courts are, it doesn't have anything in terms of a full, strong foundation that you can rely on as the final answer. Now, it's clear for all of us, and as a former appellate judge, I can tell you, we become closet watchers of Supreme Court behavior. Not only do they guide us in the appellate court, but they show us where their concerns are. And as we watched what the Supreme Court has been doing in Illinois on BIPA cases, it's impossible to miss the message. Over the past few years, and keep this in mind, on the petitions for leave to appeal to the Illinois Supreme Court, on average in a year, they take 4% of the cases that come up, 1 out of every 25 where people ask the court to consider it. But in the last couple of years, they've taken a lot of BIPA cases. Why? Because there are so many unanswered questions, and because the possible ramifications in terms of damages are so large. So it's fairly unusual for the Supreme Court to take what is called a certified question on appeal. That's something under an Illinois Supreme Court rule that people ask, and often the judge says, this issue has come up, we need guidance on what to do. And those go to the Illinois appellate court, and the appellate court makes a decision. And sometimes people ask, who disagree with the decision, the Supreme Court to do that. In the last 2 years, the Illinois Supreme Court has taken 2 certified questions and ruled on them, and in one case reversing the Illinois appellate court. And we're going to be talking about those cases later on so that you can see where the current state of affairs is. The other thing that is a good clue about the Supreme Court's knowledge and investment in trying to get this right, because of the huge volume of cases and the huge amount of money that can be at stake with a wrong decision, is in one of those cases that we're going to be addressing, Cothran versus the
White Castle.
Yeah, White Castle. I just keep thinking of it as Cothrun. Thank you, Anna. They, at the end of a very detailed ruling on a motion for the certified question to be answered, they go through a detailed analysis, parsing commas, connectors, all sorts of things to try to derive the intent of the legislature, but finish with these words, quote, "We respectfully request that the legislature review these policy concerns and make clear its intent regarding the assessment of damages under the Act." That is rare to anybody who reads Supreme Court decisions, as we all do here. They are saying, we're going to give you answers, but it would be really, really helpful if the legislature were to look at the things we're dealing with and give us a clear statement of what it is your intent is. And that has already begun to be answered. Just a couple of weeks ago, the Illinois State Senate, one of the two legislative bodies in our government, passed a bill, Senate Bill 2979, which notably passed with an overwhelming bipartisan support. And it's noteworthy because all around Illinois and all around the United States at this point, to have something that's passed on a bipartisan, overwhelming nature is very unusual. But even with the passage of that bill, there's an open question of will the other body in the Illinois legislature also pass it? Will the governor sign it and enact it into law? Now, one of the things that we just are guessing at this point is the answer to that question. And in the Cothrun case, which we'll talk about in greater detail, there was a tentative answer as to something vital in assessing damages in BIPA, which is it just the first time that the biometric information is taken that is entitling someone to damages? Or does each time that you, for example, get your face scanned or your fingerprint taken, that then every time it happens, there will be another damage? And they try to answer that in that legislation, but another question pops up immediately. Well, if it passes into law, will this be retroactive or not? In other words, the cases that have already been filed, will they be covered by this change or this clarification of the law or not? But there are many other open questions. Under the statute in Illinois, there's an exclusion under GIPA. And in that case, the Illinois Supreme Court has said that there's an exclusion to liability for people who are nurses and need to access medication and check in for that purpose. But it leaves open a number of other questions about who else is covered. Is it somebody who is an important person doing such things as keeping the books or scheduling workers, or are they excluded also? We don't know. There are questions about other ways to take information. A lot of these companies that sell eyeglasses or sell makeup have something people can access to see how the glasses would look on their face or how the makeup would look on their face. Amazon has something called their VTO that allows people to do that. There are lawsuits now pending about whether that is taking biometric information in violation of the statute. What are the limits on reckless conduct? Because negligent conduct entitles people to $1,000, up to $1,000 for a violation. Reckless conduct up to $5,000. What is reckless conduct? What is the liability for data centers that store information that are used by their customers? What kind of discretion does a court have in trying to assess the appropriate penalty under it? Identifying, assessing, managing these and other risks is so important for the lawyers and for the parties they represent. As mediators, this is what we try to provide: neutrally, dispassionately, so that settlement decisions are made with clarity and with as much as possible without undue emotion. At the end of this program today, we will be supplying case citations and article citations to the things that we discussed, so you'll have those at your fingertips. So without further ado, let me introduce Judge Jim Snyder, who will do the next part of the program.
Thank you so much, Judge Epstein. We'll take a brief pause here before Judge Snyder begins to do the first attendance poll for CLE. Just make whichever choice applies to you. We'll leave that up for a few seconds and then move right along. Thanks so much.
Thanks, folks. Folks, I want to maybe thank you for that very comprehensive overview, Judge Epstein. I want to go back a little bit broader out and then come back in. Electronically stored and transmitted data has global reach, and so do emerging regulations of its uses. And we are delighted to have online participants from all over the world today, and then many that are just down the street. The United Kingdom and the European Union, as many of us know, each have a general data protection regulation, a GDPR, that even includes to some of your interaction with this proceeding today. The Supreme Court of India has recently issued significant opinions about data privacies involving India. And I wanted to mention that there are several participants watching from India, Nigeria, the United Kingdom, and our neighbors just to the north, Canada. And I know that one participant asked in the pre-session questions if these kinds of disputes can be mediated on an international basis. JAMS is here to help you in any way we can. Any one of us would probably be more than willing to take a trip to India to work on a case with you, or to do so in a more expeditious fashion. And we're going to talk about this today. If you have specific questions, go ahead and send them in on the chat, and we'll try to address them as we go, whatever the topic may be. A number of U.S. states, as Jim has mentioned, have begun to regulate the use of biometric data, including notable statutes in the states of Colorado and Virginia. Some jurisdictions view it as an aspect of personal privacy regulation, and others as a matter of consumer rights. California, notably, comes at it from both perspectives. California has perhaps the country's most robust tradition of protecting personal privacy rights, including a statutory right of publicity and one's own personal image. Our main focus today is going to be on the state of Illinois. As Judge Epstein said, Illinois was the first state to enact legislation specifically directed as biometric information. There are many people here online who are absolute experts in this area. We're going to provide an overview of this so we can all kind of get grounded in the same vocabulary. Illinois was the first state to enact legislation specifically directed at the use of biometric information, both regulating what a party may do with that data and what a person may do protecting their rights to their own data.
Hold on a second. Can you move to the next slide, please?
Thank you.
You're still on the first slide. Yeah, go ahead.
Thank you very much. As Judge Demokopoulos has drawn our attention to, we have in Illinois, the Illinois Biometric Privacy Act, which we refer to as BIPA. We want to mention as well the Illinois Genetic Information Privacy Act, which is similar in structure, and we'll glance on it briefly. As I had mentioned, California has two primary statutes, a California Consumer Privacy Act and a California Privacy Rights Act. So if we go back to BIPA, the 2008 BIPA, well, what is biometric information? Illinois, as near as we can tell, the Illinois General Assembly, as near as we can tell, was the first legislative enactment that tried to provide a specific definition of what that term is. Biometric data is distinct from traditional identifiers of perception and recognition. The legislator distinguished biometric identifiers from other types of unique identifiers, such as social security numbers. A biometric identifier is biologically unique and immutable to a person. It's not easy to change your fingerprints. It's not easy to change a retinal scan. A biometric identifier includes retinal and iris scans, the voice print, scans of the hand, scans of the face. It includes fingerprint identification through optical scan and through traditional ink pad methods. Biometrics do not include writing samples, written signatures, photographs, demographic data, tattoo descriptions, physical descriptions such as height, weight, eye color, and things typically used in a law enforcement setting. While most imaging and sampling for collecting healthcare treatment and diagnosis, such as human biological sample, MRI, X-ray, mammography, may seem biometric in nature, these types of data are specifically exempted from this Illinois statutory definition. There are, of course, other regulations that govern the use of this kind of information, particularly on the federal level. Data can be biometric in nature and not regulated by this statute. A traditional photograph of a person is not considered biometric data, but courts have held that genetic facial geometry collected from photographs or cloud-based data is covered biometric data. For example, in the case of Riviera versus Google, the plaintiff's claim centered on digital photographs of her taken by a Google Droid camera and then uploaded to a cloud-based system. That case is called Riviera versus Google. Google captured her facial data, she claimed, and created a facial template without her consent. The district court held that this constituted biometric identifier calculation under the Act. There's another case that's significant that we draw your attention to, called Clearwater AI Inc. versus Consumer Privacy Litigation. It's from the Northern District of Illinois once again. That claim involved the claim that the defendants had scraped, the phrase they used, over 3 billion photographs from the internet, photographs that were already out there, and used an AI algorithm to scan facial geometry and create a marketable face recognition database, which included her. The court held that scraping or collecting facial geometry data from publicly available photographs could constitute the collection of non-public biometric data. Part of the thing to bear in mind with these things is at the time that BIPA was passed, the uses and potential uses and the means of collecting this kind of data was not what it is today. And this stuff is developing so rapidly, by the time this seminar ends, someone will come up with some new use for biometric data or new way of collecting it. The Illinois BIPA was trying to project itself into the future, and we now live with consequences of what they did or didn't understand. So although it's comprehensive in nature, it doesn't address things like private biological sample collection in contexts such as paternity testing, social genealogical research, or anatomical gift. But the Act intended to cast, it says, a broad regulatory intent. As I said, the scale and ingenuity of these technologies is changing more rapidly than anybody can keep track of. So what can a party do with another person's biometric data? Illinois BIPA Section 15, as you see here, indicates that a party may not collect, capture, purchase, receive, trade, or otherwise obtain another person's biometric data without first providing notice and obtaining a written consent. One little segue, BIPA itself from 2008 is old enough that the Act talked about obtaining a written consent. I don't know when the last time anybody here physically signed a piece of paper was, but we can't even keep track of keep fully up to date with how rapidly these things change. It also includes a section 15D. A private party may not disclose, redisclose, or otherwise disseminate this data without the person's consent. So it regulates restricting and collecting the data from some other party and distributing it once again to a third party. Most BIPA claims stem from an allegation that a party has done one of those things. And if so, what? Moving on rapidly to the remedies section, which is perhaps at the heart of the matter. The Act at Section 20 creates a private right of action, including a right for class action. California court decisions have also interpreted their state statute as inclusive of class action. There's a case called Renderos versus Clear Eye AI. Again, the same defendant in the Superior Court of Alameda. It's a trial court order, but it's often cited as the order that suggests that those two California statutes also include the idea of class action. And in fact, like Illinois, the possibility of nationwide class action. Turning to the section on remedies, Illinois remedies specifically noted in the statute include the greater of liquidated damage of $1,000 or actual damages. And in this case of recklessness, a liquidated damage of $5,000 plus attorney's costs and fees and injunctive relief. And so that $5,000 damage, that $1,000 damage for violation of the Act sets the table for the discussion of Cawthron, which Judge Demacopoulos is going to do. And if we could flip slides.
Thank you, Judge Snyder. We'll take a second brief pause for the CLE polling. Please make whichever choice applies to you. And we do, while you think about that, we do have one question from the audience asking how law is chosen when there are multiple statutes for similar issues. So maybe a choice of law question there for the panel.
Thank you, Judge Snyder and Judge Epstein, and welcome everyone from around the world actually to this seminar today. We really appreciate your time. I was very fortunate that when I got onto the bench, I was assigned to the Chancery Division just when all of the BIPA cases and the privacy cases were hitting the Chancery Division, and so got to see how all of these issues were beginning to come to light. And I will say that judges have different opinions. And so many of us did have different opinions on how a lot of these issues were going to be resolved. The biggest issue that we all were struggling with, or at least were deciding, was whether or not every single scan, every single time somebody's biometric information was taken, was actually going to be a violation of the statute. And what would the penalty be? One of the questions that we have in the chat feature is, how do you address the choice of law question and whether or not there are different statutes that apply and whether it's a fate or a state issue? As Judge Epstein has indicated, most of these cases, all of the cases concerning BIPA, the Biometric Information Privacy Act, will be decided eventually by the Illinois Supreme Court. In other words, they are going to be the ultimate decider because it is in fact a state statute. But in what we saw in Cawthron versus White Castle was the case originally started in Cook County, in the Circuit Court of Cook County, in the Chancery Division. White Castle then removed the case to federal court. While the case was in federal court, decisions were being made. It eventually went up to the Seventh Circuit, and the Seventh Circuit then certified the question, and it came back to the Illinois Supreme Court. And the question that they certified was, Do sections 15B, which is the collection, and 15D, which is the dissemination claims, accrue each and every time a private entity scans an individual's biometric identifiers, and whether or not the private entity transmits that scan to a third party, or whether or not it's the first scan and only the first scan that's transmitted. The Illinois Supreme Court ruled that they have to consider what exactly was the legislative intent. And although the legislative intent is not within the statute, they could not contemplate that the legislature actually considered that it would annihilate or could destroy an individual business. However, what they did rule was they have to look at statutory construction and look at the plain language of the statute. The Supreme Court held that a trial court presiding over a class action, a creature of equity, and I'll keep that in mind for a question later that I have for the panelists, would certainly possess the discretion to fashion a damage award that is, one, fairly compensated claiming the class members, and two, included an amount designed to deter future violations without destroying the defendant's business. So basically, the Illinois Supreme Court said, you kind of have to do a balancing test. And what they read into the statute is that even though there are liquidated damages that are defined based on either negligence or reckless or intentional conduct, it is still, in fact, discretionary. And the language of the statute does not authorize an award that would financially destroy a business. And so after Cothran, we saw a change a little bit in the value that was happening in the settlement of these types of cases. But as Judge Epstein actually mentioned, the last line in the opinion states as follows: we respectfully suggest that the legislature review these policy concerns and make it clear what the intent was as it relates to damages. And as Judge Epstein has indicated, we are currently faced with a situation where the Illinois State Legislature, the Senate, has passed a bill that would basically say it's one person gets the remedy. In other words, it's per person, not per scan or per violation. It's per person. But we'll wait and see what happens with that legislation. We know that it could be amended. Judge Snyder has indicated that we don't know what's going to happen. Jim, do you want to chime in here a little bit about the legislative process and what will happen?
Sure. You know, as Jim and Anna have mentioned, and sorry if we're slipping into first names, we can't help it. We're longtime friends and colleagues. The Illinois Senate has passed a bill called SB 2979. There are, on that choice of law question, there are few things more final than the state Supreme Court, in this case Illinois, doing an original statutory interpretation on the meaning of a statute, which is what they did in Cothran, and they indicated, I think, elliptically, hey, this is what you wrote in this statute. Are you sure this is what you want to do? Take a look, and that's what the Senate has done. The General Assembly considered this legislation in the last session and did not reach consensus. In fact, wasn't called for a vote. Currently, Senate Bill 2979 passed the Senate. It changes the statute only in two ways. One, a little one, but I think an interesting one. It provides, to my knowledge, the first definition in Illinois law, statutory definition, of what an electronic signature is. And it basically says, use your common sense. And we'll start to see that more and more. And it will allow for an electronic signature option on authorized retention or use. And then the other thing, most significantly, as Judge Demacopoulos has said, indicated one violation per collection, one violation per dissemination, one violation fee based on the action of the party. Because of course, one party could collect it and another could store it or disseminate it, third parties, fourth parties, etc. It still allows for actual damages. It still allows for the other damage provisions. It was this morning assigned to the House Civil Law Judiciary Committee. which is the logical place for it to go, the committee that handles civil law changes. I think, as Judge Demokopoulos has indicated, there may be further changes. There are people in the business community who have wondered how this will affect cloud computing and the fact that Illinois is becoming a data center, a place for data centers. I think, in my unscientific way, the cloud has to touch the ground somewhere, and Illinois and its current governor have put significant resources into developing data centers in central Illinois, and will do nothing to upset that potential development. And I think parties involved are still discussing how this proposed legislation may or may not affect them. That's purely speculative on my part, just based on someone who worked in the legislative background at one point. But I do think, most people do think, that some legislation on this act will reach the governor by May 31 of this year, and for his consideration. So it remains to be seen. I guess the final point on that is, we're, like every lawyer in Illinois, everyone here at JAMS, the three of us are certainly watching this on a daily basis. So we're up to date on wherever the law may be. And also, one other thing, the people have asked for for this legislation to include retrospective relief. It does not. And I think that's turning over to the next topic here.
Yeah, can we go to the next slide? And my fellow panelists, we're really running a little bit behind, so I'm going to try to cut it short. And I think we want to get to the end of the seminar as it gets to the mediation. While Cothran was pending, the only case that we are all aware of that has ever gone to trial on the merits of a Biometric Information Privacy Act violation was Rogers versus BNSF. After multiple attempts to try to resolve the case through mediation with a very fine mediator, the case ended up going to trial in federal court. At that time, Cothran was still pending. The jury was instructed on the damages of liquidated damages of $1,000 for negligent. For negligent, and $5,000 for intentional or reckless. The jury came back with $228 million jury verdict. However, that was subsequently vacated by Judge Connelly after Cothran came back because the jury was not instructed as to the discretion. Now, what's interesting is still an unresolved question that I'm going to ask my fellow panelists is the question of whether or not the conduct is discretionary, is that a question of fact for a jury or for a judge? Judge Epstein.
Well, like most of the things we've talked about, it remains to be seen. I would think that regardless of what the jury does, the judge is going to have to decide whether the judge thinks it's in his or her discretion it should be changed. But if a judge does that after having submitted the issue to a jury, there will be an appeal on whether the judge exceeded his or her authority by weighing in on that after the jury considered it. So the unwelcome answer to that question is add that to the risk category.
Judge Snyder, one word answer, jury or judge?
I think just that last sentence just said it. I think I love that lawyers are smart and creative and they keep looking for new approaches to cases. I think Judge Connelly's memorandum opinion in BNSF is a much-read opinion, and I think that the last thing you would want to do is the case that goes to the 7th, to the Illinois Supreme Court, around the mulberry bush, to kind of nail this specific issue down, that be your case, and bake this into your risk calculation.
Yeah. So ultimately, the case has been settled, and a preliminary approval is currently pending. The agreed upon amount was $75 million. And going back to the question of law, the case is actually being administered in the Circuit Court of Cook County, even though Judge Connelly has approved final approval. We have a question that indicates, can you clarify your understanding of whether the BIPA amendment would apply retroactively to pending cases? Again, the legislature has not ruled on that. They have not decided on that. It is a possibility. But again, this goes back to what Judge Epstein said at the very beginning. When you have a case and you are determining whether or not you should settle the case, that is another risk that you take. In other words, when those cases were pending in the Chancery Division, actually some of the judges, including myself, we actually made the defense tell their clients, look, there's a possibility that the Illinois Supreme Court will come back and say, every scan, every swipe is a violation. Make sure your clients understand the risk of going forward here and staying the proceedings. It could happen again. We don't know if the legislature is going to say it's retroactive.
I also believe that a plain reading of the existent legislation, the bill that the House has, does not include retroactive relief. It has an immediate effective date, and I think that then folks can argue that that is retrospective in aspect, but it is the case, an aspect of, and a component of the current legislative history of 2979, the pending thing, is that members argued that retrospective relief should be included, and the bill was not included to specifically amend to include that. But it's open. The House could do it.
Yeah. We can go to the next slide, and we are at 18 minutes left, gentlemen. So I think we need to watch our time. Judge Snyder on Tim's.
You know, I think we should very quickly go forward and say this is a pretty straight ahead statute of limitations decision. It's interesting, as Judge Epstein noted, that the Supreme Court considered more than one BIPA case in the last few years, and maybe move forward.
Joe, do you want to do the poll now?
Yeah, let's go ahead and launch the third and final poll. Make the choice that's right for you. And we'll leave that up for another 15 seconds before moving on. Thanks so much.
Excuse me. All right, as Judge Epstein had indicated, there are a lot of unresolved issues. One of the issues that was recently resolved by the Illinois Supreme Court is the exclusions that are defined in the statute. The first one is Mosby versus Ingalls Memorial Hospital, where the Illinois Supreme Court basically said that BIPA covers not only the particular source of the information, but the purpose in which it was being used. And so the exemption for healthcare workers that were using their fingerprints to actually get the medication for the patients, those individuals were excluded from BIPA. Some other unresolved questions that are still lingering at the trial court level and even some at the appellate court level is the exclusion concerning government contracts. The statute indicates that if you are a government contractor, you are excluded from BIPA. However, how do we determine how much of the business aspect of the defendant is actually being used for government contracts? Is it limited to that portion of the business, the percentage of the business? Who knows? These are all factual questions that still haven't been used. Another common case that is coming into at the trial division now is different types of tools that are being used not necessarily for identification purposes, but rather what we call try-on tools. Try-on tools for makeup, try-on tools for eyewear, makeup or hair colors, things of that nature. In other words, the introduction to BIPA indicates that BIPA was intended for purposes of retaining individuals' privacy concerning their identification, but the statute itself doesn't say that the information needs to be used for purposes of identification. There's a difference of opinion at the trial court level. In the Clearview cases, there's the question of whether or not the Dormant Commerce Clause is used, which is a clause that indicates that it prohibits state legislation that discriminates against or unduly burdens interstate or international commerce. Again, different trial courts have ruled different ways. Those are all issues that are still unresolved, which goes to the risk and whether or not you should try to settle the case. We can go to the next slide. You can actually skip unresolved questions.
Very briefly, again, because we want to use our time well, there exists in Illinois a Genetic Information Privacy Act that has not been the source of a tremendous amount of legislation. There's much we could talk about here, but we'll maybe in the interest of time go further, other than to say that the penalty and remedies structure is similar enough in this statute that one would suspect that the court would apply a Cawthron-like analysis to how it applies. And there's no bill proposing to change it, by the way.
Yes. Next slide. This is Judge Epstein on insurance coverage. Oh, you're muted, Jim.
One of the other areas where we've had an explosion of litigation has to do with insurance coverage, whether the policy, the general liability policies, or anything else in the way those coverages are enunciated in the policy, covers or doesn't cover a BIPA claim. And obviously, with the amount of money that can potentially be at stake, that is become a huge issue. And it's not unusual, in my experience in doing the mediations, to have either of two circumstances. One is that there is an insurance representative who is there trying to help settle the case, but letting the defendant know that there is a limit beyond which they will not go, and it will be up to the defendant to do it, even if that limit isn't the limit of the insurance coverage in general, because they're asking the defendants to bear some of the risk that they'll be found not to include a BIPA claim. And sometimes, and oftentimes actually, there are cases where there is no insurance representative there. They're playing chicken with their insured. So this whole area is growing, and as with anything in the insurance industry, the existence of this and the volume of claims has spurred rewriting and clarifying insurance coverages. So this is something that, without going into great detail, is another huge issue. And for people who try to get insurance, they want to make sure that their insurance coverage includes a biometric information coverage.
Next slide, please. So as Judge Epstein and Judge Snyder and I have all indicated, this is all about risk. Like, what is the risk of me going down the litigation path versus me trying to settle the case? And these mediation tips are not unique to just BIPA cases. They are unique to all types of cases, particularly class action cases, when we try to settle them. The next slide, please. Many times we'll get submissions, and the first thing that we read is for the next 10 pages is how strong the plaintiff's case is. When you are in mediation, we understand that the strength of your case, everybody believes that their case is strong. Nobody starts a lawsuit thinking they're going to lose. Everyone thinks they're going to win. But what people don't consider is, what is the actual cost of winning? And what does that win actually look like? And for class actions, particularly in the privacy arena, you really have to take a step back and think about that, right? Some of the things that you also should consider is, what is the defendant's ability to pay? If you're dealing with a mom and pop kind of shop that may have maybe 40, 50, 100 employees versus a huge corporation, those are all things that you need to take into consideration. The likely complexity, length, and expense of further litigation. You take the risk that if you continue to litigate, you're going to be in another courtroom called bankruptcy. That's the last thing that you want to do. So even though you may have a strong case, settlement may be the best thing for you. What is the opposition to settlement from members of the class? In other words, are you making the class happy, or are you going to be drawing an objection later on? All class action lawsuits have to be approved by a judge. So even if you settle in a case, that class action lawsuit has to be approved by a judge. And one thing that you have to avoid is the evidence or appearance of any collusion between yourself and opposing counsel. You need to take into consideration what are the opinions of your opposing counsel. What stage of the proceedings are you at? What's the amount of discovery that you're looking at? Have you completed discovery? These are all things that you need to take into consideration in considering whether or not you should go into a settlement conference. What's the public's interest in doing this? Next slide, please. What type of business is it? How many class members are there? Are the class members laborers? Are the class members union members? Now for BIPA, that doesn't count anymore, right? Because the Supreme Court has ruled the collective bargaining agreements are precede or preempt the BIPA statute. So union members don't apply for BIPA. However, and other class action members, these types of questions will determine, is it likely that you're going to be able to reach the class members? That's the key. How many class members are you going to be able to reach? Is there a high turnover of the class members? How many members are still working for the defendant, if they are? Will the class members be receiving a check? And we're going to talk about that in just a little bit. Or are they going to be a claims form type of settlement? Is the defense funding the settlement by insurance money, or is it the individual business that's actually going to be funding this? The next slide, please. And this is where we find in mediations that what I call the pressure points. Is this going to be a claims made type of settlement? Is it going to be a direct check kind of settlement? And is there going to be reversion? And here's why I consider them to be the pressure points. This is where judges are paying the most scrutiny, because a judge's role is to determine whether or not the class is adequately represented. Excuse me, I thought I'd get through the day, but I couldn't. This is where the pressure points are. This is where judges are going to be looking at it, right? And I will say that, and I'm open to, this is where I think the panel can jump in here. You have to be creative in these settlement conferences, right? It doesn't have to be just claims made or just direct checks or no reversion at all. You can get creative. And that's the beauty about settling class action lawsuits in mediation. The clients have the control. The clients have the decision making. Once you get past that, it's very difficult because then the judges are making those decisions. So you can combine a recent one that I just did. We combined claims made with direct checks. There was a reversion to the defendant based on certain circumstances. And so this is where what I call the pressure points,
Anna,
where we find, yes, go ahead, Jim.
I just think for people who might not understand what reversion is, it's used to describe it in some detail. Some of the structure of a class action can include a reversion, which is if, for example, there's a fund amount and it's a claims made structure where people have to apply for it before they get their set amount of check. If there is money left over after that, a reversion would say where that money goes. And in some cases, it would go in all or in part back to the defendant under those circumstances. It's something that's very popular with the defendants, not really popular very much with the judges in that, but it's something that that comes up regularly, and it's why structure is an important part for the lawyers on each side to communicate about well before the mediation begins, and then we can discuss it in the mediation.
And I would only add two things to that. One is parties can and should use a mediator to allow yourselves to share information, help you manage your own client's expectation, help you find creativities, such as, I think as Anna has suggested, the settlement of this case need not be like the settlement of any other. And it can have metes and bounds and ideas to it that are unique to it specifically, but not so much so that a court won't sign off on it. And use a mediator to help you through that process to figure out how a court might react to it, what the unique things are, and have that happen rather than have that happen in the courtroom when you see the judge.
Next slide, please. So those of us that sat on the bench that were approving these, the question was, well, do you ask these questions at the preliminary approval stage or at the final approval stage? And I learned very, very early on that it's best to address those at the preliminary approval stage. And here's the reason why. That's when a judge has more leeway, have more flexibility when they address these issues. But for you folks that are now handling these cases, next slide, please, the best place to handle it is in mediation. Now is when you should be asking these questions so that you don't have the problem. The last thing that you want is to come to a settlement agreement and then you get to court and the judge doesn't approve it. So you need to know you need to know your venue. You need to know what's happening in that circuit. You need to know what's happening in that county on reversions, on claims made. You need to know the temperature. And these are the things that you can work out in mediation. That's why this is the best way to do that. What we have available for you too at the end is you will be receiving the JAMS class action checklist that can help you facilitate and be the best prepared when you go into the mediation session. We understand that not everything is going to be resolved, but at least it gets you talking to your client, gets you talking to your opponent about the things that will be addressed in the mediation session. Do we have any questions, Joe, that we haven't answered in the chat?
We do have one, and the participant is asking, how do you view arguments that have been recently made that plaintiffs can only assert BIPA claims post-dating the Rosenbach decision?
I haven't heard that argument, but I guess my gut reaction, my response is you have to deal with the statute of limitations issue, right?
I agree.
So yeah,
if it's within the statute of limitations, then I don't see that as a problem.
I mean, I think that's true for any case. That's true that Tim certainly talks about use a statutory approach, and as well, you know, the majority of the members, this is just a side note, the majority of the members of the Illinois Supreme Court have been on that court fewer than 4 years. And if there was any kind of feeling for who that court is, it's a follow the statute court. And they say, here's the statute of limitations. The act was passed in 2008. Apply it to your case. And that seems to be the kind of court that we have. Other questions, Joe?
If I can just say one thing about preparing for a mediation, we all have our instructions that we give people who are coming in. And what I like people to do, I can't order anything, I'm only a mediator at this point, is to share your pre-mediation submissions with the other side so they know what issues are going to arise. And hopefully there'll be proposals from each side for settlement in advance, so we don't have to go through a dance about who's going to go first, or people expressing shock and awe at what the other side is looking about. And think about and discuss the structure, like we were talking about with direct, check, claims made, reversion, so that those things are on the table. What I do is I have a joint call with all the lawyers in advance of the mediation day, and I follow that up with individual calls with the lawyers for each side, so they can tell me their view of the case, including hopefully admitting some of the weaknesses that I see in the case, so that I know what I have to be spending my time with. I also ask them to tell me about their clients' orientation to us, and they'll tell me usually, hey, my guy's a realistic business person. He knows what this is all about. Or my person, I just have to try to ride him. He's just completely emotionally frayed on this. And that tells me I have to do a little bit more at the outset to try to get that person to think about things from a business point of view, and have what I call open your veins and bleed conversation with that person, where they tell me how unfair this whole thing is. And I usually express sympathy and understanding of their emotion, but say, this is a binary choice. Are you going to settle this case, or are you going to opt for plan B, which is spend a lot of money and maybe find out, like the defendants in Rogers versus BNSF, that was a really big mistake.
I mean, my real quick goodbye and thank you comment would only be, part of the fun for us as retired judges with working with JAMS is trying to stay on top of the law and getting and learning from all of you. We enjoyed putting this together, whether it's BIPA, mediation skills, or anything that you want to chat about in future education sessions like this. Just send somebody at JAMS an email, and we're delighted to talk about it and work on it.
I too want to thank everybody, and if you need anything, I think that everyone has our contact information. Thank you so much for coming and joining us today, and we look forward to working with you in the future.
Thank you to the panel and to our partners at Mondac. As a reminder, we'll get you the slides and that class action checklist in an email shortly after the presentation today. Thanks for coming, and be well.